cover today. I don't know that we're going to have the time to do a full-fledged discussion on the abortion issue and on the Dobbs ruling, but certainly that was probably the biggest news that we missed out on, was that Dobbs ruling that came down that overturned Roe v. Wade and Planned Parenthood v. Casey, those two cases that essentially made abortion legal nationally. And so there's a whole lot to dive into there. Everything from the originalist nature of the court opinion itself to, what was said by the dissent, what was said by Chief Justice Roberts. I mean, if you're a legal wonk and you're into constitutional law and constitutional scholarship, all of that might be very interesting to you. A lot of that's not getting covered in depth in the news. Most of what people are focusing on is sort of outcome-based talking points, and some of which are not even true, right? Because, we're hearing a lot of that as though somehow abortion has now been made illegal in the United States, which is actually not the case. All the opinion did was say that the justices of the Supreme Court are not legislators. That's really all the opinion said. And they can't just make up law willy-nilly just because they want to solve what they perceive to be some injustice or some crisis in the law, which is exactly what happened in Roe v. Wade. In Roe v. Wade, different states were in the process of having different laws. Now, every state within the United States at one time or another has made abortion illegal. Some of them, it's now legal in those states by state law, but what Roe did was take that away from the states to decide and said essentially somewhere within the Constitution, we couldn't really tell you where, right? Don't try to actually find the words that say this, but somewhere within there's something called a right to privacy and substantive due process. That involves your right to privacy. They say it's in the penumbra of the Constitution. That's kind of like the halo around the Constitution, like the steam that comes off the Constitution. That's the penumbra. That's what's it's not really in the words. It's not in the Constitution, but surely it's just sort of part of, the whole feeling from the Constitution. And what does that mean? That means it's not the rule of law, right? Because then you could just make up whatever you want. Then any 9 justices can sit there and say that it may not be actually written in the Constitution, but we find it in the penumbra. That's exactly what they did in the Roe decision. And so that amounts to legislating. Congress could have legislated to make abortion legal in all 50 states, perhaps, or the individual state legislatures could have legislated that in each individual state. That's the way it's supposed to work. The individual states are supposed to decide the issues, right? Under the 10th Amendment, the federal government is a government of enumerated powers. What the Constitution says the federal government can do, the federal government can do. What it doesn't specifically say, and this is the 10th Amendment, by the way. This is not in the penumbra. This is in the text of the Constitution. You could pull it up yourself and find it. The 10th Amendment to the Constitution. The powers that are not expressly granted to the federal government are reserved to the states. So anything that the Constitution doesn't say the federal government can do is reserved to the states. Now, the workaround that the federal government has employed largely is reliance on what they call the Commerce Clause. And a lot of this comes out of the Civil Rights era, right? It comes out of, hey, we want the federal government to step in and make some rules that say that these states can't continue making their own laws and applying their own laws in the way that they want because we think that's racist and it's bad. And maybe, if you're just looking at it, maybe it was racist. Maybe it was bad. I'm not saying it's not. But the point is, should the federal government have the right to do that? And where is that found under the Constitution? So what they did was they said, well, the Interstate Commerce Clause, the federal government has the right to regulate interstate commerce. And because, and remember, this had to do with a Woolworth's diner. I believe it was in Birmingham, but it might be Montgomery. But anyway, I think it was Birmingham. Anyway, it was a Woolworth's diner. This, by the way, was happening all across the Deep South. So it wasn't limited to one diner or one restaurant, but it was where black people were not allowed to sit at the lunch counter. And then I think a black person did sit at the lunch counter, refused to get up and leave when they said you can't sit there, and then I believe was arrested. And so this wound up sort of giving rise to this idea that, wait a minute, the diners, they might be serving customers who've traveled interstate, because many times people who are traveling interstate will stop at diners. And they might be ordering products and goods, and they might be importing things from other states, not just things to sell, but maybe part of their food products. And so this gave the basic rationale to say, well, therefore, they're involved in interstate commerce. Therefore, Congress, under the Constitution, does have the power to regulate this issue. And so, therefore, we get to the Civil Rights Act. Now, that, of course, there's really no bounds on the Interstate Commerce Clause when you can make it that indirect, because at the end of the day, they can always come up with some argument or some reason why, this actually does have some effect or could have some effect on interstate commerce. And that's one of the ways the federal government has so radically expanded its power beyond the enumerated powers in the Constitution, beyond what was intended originally for the federal government, and beyond legality, frankly, as contained in the 10th Amendment, which says that those powers that are not specifically enumerated to the federal government are reserved to the states. So the states are the ones supposed to be making this law. So that same principle is what we saw at play in the original Roe decision, and we saw the federal government again stepping in and finding something in the Constitution that I think even more clearly than the Interstate Commerce Clause overreach that they've done over many years. This is even more clearly not in the Constitution. The right to privacy, frankly, and the right to an abortion is not in the Constitution. And so they added it. And they said, no, we're going to find that that's in there, and this is going to be the law. And then they made up the stuff about, trimesters. All that was made up. It was not scientific. They acted in a legislative fashion. They essentially wrote a law to be applied. Now, Casey, the later decision, then kind of got rid of some of that, did away with the trimester breakdown, which, again, is clearly legislative in nature, to say, well, in the first trimester, it's always okay. In the second trimester, it's okay in some circumstances, but not others. In the third trimester, it's not okay in most circumstances. I mean, that's it, just to kind of summarize it for you. That's what the Roe decision set up. That wasn't something they were repeating that Congress had passed or any legislature had passed. That was something they just made up, their scheme for how to deal with abortion. And 9 people, that's not the way the government works. The government is of and for the people, right? I mean, it's the government's power comes directly from the people. The government isn't in charge absent our consent to be governed, absent our willingness to allow it to continue in power. It's not a separate entity. This is not the King of England. It doesn't claim some right coming directly from God that's separate that we can't veto, like the King of England or the Queen of England would. That's not what we're dealing with here. We're dealing with our American Republic, which was set up specifically to be totally beholden to the people, and the people act through their legislators, and that is why Congress is actually, although, yes, there are 3, quote-unquote, co-equal branches of government. You ever notice the way the Constitution is set up by article, and maybe you have and maybe you haven't, but you can look into it. Article 1, we're talking about the Congress. That is the primary branch of government because that is the government that expresses the will of the people. And you can find this in the Federalist Papers and the other writings of the time, that these are the philosophical underpinnings for the way that they set up our government. So it is not supposed to be 9 unelected justices making the law. It is supposed to be the legislature, which is subject to the election, right? Subject to the will of the people that makes law.
You did a great job of explaining the legal ramifications and rationale behind it. This also, my observation, fires up the Democratic base.
Well, we'll see. I mean, I'll be honest with you. Polls so far don't show it, and I'll also be honest with you. The Supreme Court can't be making decisions about the law based on how that will affect people's feelings or whether it will fire up a base or not fire up a base. The Supreme Court's supposed to make the decisions based on the law, based strictly on the text of the Constitution and the text of a statute. So they're not supposed to be considering things like I think Chief Justice Roberts wanted to consider, which is what might come from this. Will people riot? Are people going to throw Brett Kavanaugh out of Morton's Steakhouse in D.C.? Well, maybe we shouldn't do this.
Thank you for listening to the Morgan Streetman Show. We hope you enjoyed what you heard, and if you did, please click like and subscribe to help us out. And remember that we recommend that you exercise your brain at least once a week.